I, Prakash Sharma, will be serving you as a court master and will be assisting you with maintaining the decorum and to assist the honorable bench. The court master will act as facilitators between the bench and the counsel. The court master will time the arguments and intimate the bench accordingly. Your lordship is requested to please seek our assistance whenever it is required, as stated in the rules of Lawvs National Moot Court Competition 2025. Each team will get 30 minutes to present their case, including 5 minutes will be given for rebuttal and sub-rebuttal. Subject to the discretion of the honorable judge, each team shall intimate the court matter in regard to division of time between speakers. Only one speaker from each team shall be permitted for the rebuttal and the sub-rebuttal. The order of presentation is petition number 1 is speaker number 1, petition number 2 is speaker 2, and respondent is speaker 1, and respondent from the respondent team there is a speaker number 2. रिबटल के लिए कोई भी हो सकता है फ्रॉम पेटिशनर साइड और रिस्पोंडेंट साइड, ठीक है. द जजेस में exercise discretion for extending the time for the oral rounds beyond the time specified in the rule book. The rule book provides that time extension up to 2 minutes if permissible for each round. The team code 7 and team code 47. The team 7 represent to Career College of Law and 41 represent to University of Law College. I would now like to seek the permission of the bench to start with the proceedings.
Please, you may start.
Am I audible, Your Lordship?
Yes, you're audible.
All right. The counsel seeks permission to address the bench as Your Lordship on behalf of petitioner, that is Govind Das and others, in a matter of Govind Das and others versus the state of Uttar Pradesh and others. Your Lordship, with the due permission of the bench, the counsel seeks permission to state the jurisdiction. Much obliged, Your Lordship. The petitioner have approached the Honorable Supreme Court of India under Article 136 of the Constitution of India. The petitioners most humbly and respectfully submitted to the jurisdiction of the Honorable Court. Your Lordship, with the due permission of the bench, the counsel seeks permission to state the statements of fact.
No, there is no requirement to go through the statement of facts. You may straight away come down to the arguments as far as the concerned issues are framed. Have you gone through the issues?
Yes, Your Lordship.
Issues for consideration?
Yes, Your Lordship.
Please straight away argue one by one on that.
Okay, Your Lordship. Your Lordship, it is most humbly submitted before the Honorable Court that the High Court mandamus under Article 226 directing the state to implement the Bake Bihari Temple Corridor scheme amount to impermissible judicial micromanagement. While the High Court power wide under the Article 226, such power are subject to constitutional limitation rooted in the doctrine of separation of power. The doctrine of separation of power is a part of the basic structure of the Constitution. The role of the judiciary is to review the legitimacy of the executive action or inaction, not to supplement the executive's wisdom with its own. It is not the function of the judiciary to sit in a judgment over the matter of administrative policy. It must be left to the discretion of the concerned executive authority. In a Union of India versus S.B. Mohra case, the Supreme Court underscored that although Article 226 is wide, its exercise is restrained to prevent court from overstepping into administrative domains. Your Lordship, in the present case, the Honorable High Court did not merely direct the state to fulfill its constitutional obligation to ensure public safety. It specifically direct the implementation of large-scale corridor project based on a model of Kashi Vishwanath corridor, involving the demolition of over 300 structures and acquisition of 8 acres of land. This amount to the clear and direct formation of policy, a function exclusively reserved for the executive. In so doing, the High Court assumed the executive role, hence violate the doctrine of separation of power. Your Lordship, it is submitted that in the present case, High Court mandating a specific project model, eliminating executive discretion to explore a range of alternative and potential less restrictive measures to achieve public safety. This could have include tech-enabled crowd management system, staggered darshan timing, regulating the festival time football, narrowing the project scope to only essential safety features, and selective retrofittation. This amount to impermissible judicial micromanagement. Your Lordship, it is respectfully submitted that judicial reviews
Counsel, may I interrupt you for a minute? Please tell me whether this corridor project was framed by the state?
Yes, Your Lordship. This
submitted before the court?
Yes, Your Lordship.
So where was the court wrong in not permitting the state to go ahead with the project?
Your Lordship, while High Court was rightly concerned with the safety after the tragic stampede and the corridor which is proposed by the state, the form of its mandamus went beyond ensuring compliance with constitutional duty by directing the state to initiate an executive specific corridor scheme. The court effectively tied the state's hand to the single infrastructural blueprint, Your Lordship, thereby substituting its own policy preference for range of options available to executive. By directing that implement particular corridor by ignoring the fact and arbitrariness of the corridor or other factors is kind of a, Your Lordship, is beyond the impermissible. Yes, Your Lordship.
What were the other options available? What were the other options available before the court?
Less restrictive measures being available before the
any other alternatives or corridors suggested by the petitioner before the High Court?
Your Lordship, no other corridor has been suggested by the petitioners. It is said that less restrictive measures has been provided by the petitioners to look through. Your Lordship, making a corridor also impact the environment, heritage, and other factors, Your Lordship.
Okay.
Also, Your Lordship.
And what about the safety, order, accessibility, and other things?
Your
With
Lordship,
respect to the public safety,
Your Lordship,
and convenience?
Yes, Your Lordship. Your Lordship, these can be secured by other less restrictive measures, means such as, Your Lordship, such as high enabled crowd management system, Your Lordship, staggered darshan timing, making entry exit points, regulation of festival time footballs. Again, Your Lordship, these are the measures. Also, Your Lordship, CCTV monitoring and online booking system. All these things can be done to prevent the stampede, and we worked for the crowd management, Your Lordship. Your Lordship, in as we know that recent 2025 Mahakumbh Mela, which is held in a Prayagraj, Your Lordship, there is also containing the 66 crore devotees participated all over the world in between 40 days, Your Lordship. And for that, many crowd management measures have been taken, and which shows that like these things can be managed by less restrictive measures, Your Lordship. Your Lordship, in Bajirao Tote versus Statement of State of Maharashtra, it is said that, Your Lordship, my apology, in a film festival and others versus Gaurav Ashwin Jain and others, it is held that the scope of judicial intervention when examining a policy of government is to check whether it violates fundamental right of a citizen, opposed to provision of constitution, opposed to any statutory provision. Court cannot direct policy either on a ground that it is enormous or
that was the reason why counsel at the very first stage asked whether the policy and or whether this project was formulated by the court or whether it was placed before the court for its consideration by the state. You said that it was
Your
formulated by the
Lordship,
state
though,
for the consideration of this court, right?
yes, Your Lordship.
So
But
therefore,
Your
this
Lordship,
was the
in multiple,
this was not the policy which was being examined. This was the suggestion and or the policy which was placed before the court for its consideration.
though
So there is
we
a
agree,
difference,
Your
no?
Lordship, that the, yes, Your Lordship, we agree that it is proposed by the state and judiciary looked for this proposed corridor plan. But the problem here is, while directing that this corridor should be made and overlooking the other measures by the High Court presented by the petitioners, it says that judiciary not look over the arbitrariness. No public consultation has been done. No EIA, environmental impact assessment, has been done, and directly come to the conclusion that the corridor should be made. It's arbitrary, Your Lordship, and violates the due procedure of the court.
Okay.
Sorry
May I
for the
proceed, Your
interruption.
Lordship?
Last 2 minutes are left for the speaker one.
Oh, okay. Your Lordship, may I proceed with the issue number 2?
Certainly, if you've taken all this time to, just examine and tell the court that what all powers under 226 the High Court has, then I believe, you'll not be able to touch the other remaining issues. Please go ahead,
So,
fast.
so may I go ahead of these issue
Certainly,
number 1, Your
certainly,
Lordship?
please.
Thank
With
you much.
whatever
Thank you
with
so much, Your
whatever
Lordship.
little time you have.
Thank you so much, Your Lordship. It is humbly submitted by the petitioners that the creation of large-scale infrastructure involves complex consideration of town planning, heritage conservation, environmental impact, and social economical rehabilitation field where the judiciary lacks institutional expertise. By mandating a single corridor project, the court inadvertently bypassed the necessity of these nuanced considerations, which are typically addressed through expert committee, public consultation, and interdepartmental deliberation within the executive. This has led to the present embryo pitting public safety against fundamental right to livelihood. Your Lordship, the state, under the guise of Article 21, which says the protection of the devotee's life, while overlooking the right to livelihood under Article 21, which is also a fundamental right, by overlooking the right to clean environment, which is again a fundamental right under the Article 21, right to be heard, which is also fundamental right under Article 21, right to practice religion under Article 25 and 26, which is again the violation of fundamental right to fairness, and right to property, which is though not a fundamental right, but again it is a right that other resident have, and right to fair compensation. All these rights are overlapped on just one right that state has been proposing in front of the High Court, Your Lordship.
Speaker number one, your time is concluded. There is a chance of speaker number two from your side.
Sir, I just like to seek the permission of the judge to proceed for the issue number 2 and extension of a time.
No, would not be granted. Thank you. Let the speaker number 2 go ahead. Speaker number 2, at the outset, I must say, you should not touch those issues and repeat the arguments which have been advanced
Sure.
by your colleague, right?
Sure.
Please make your submissions with respect to the remaining untouched issues.
Sure, Your Lordship. Greeting to the Honorable Bench. I will deal with the issue number 3 and 4, and your permission to begin with the issue number 3.
Sure.
Your Lordship, the issue number 3 is whether the state objective of crowd management and public safety under Article 21 justify the large-scale demolition and redesign of the organically evolved precinct when less restrictive alternatives available. Your Lordship, the petitioner submits that the objective of ensuring the public safety is a legitimate goal, but the means adopted here, like the large-scale demolition of the sacred precinct, fails the doctrine of proportionality, Your Honor. In the case of K.S. Puttaswamy versus Union of India, the court adopted a proportionality test which require four things. The first one is it should have a legal process, it should have a legitimate aim, it should have a necessity, and also the suitability. We accept that there was a legitimate aim of the public safety, but it fails the test of necessity. That is, there was a less restrictive alternatives available. Your Honor, in the case of modern dental college versus
So sorry. Like what other alternatives were available and were brought before the court?
okay, like there was the online booking system, or we can say a slot for the darshan, and the CCTV for monitoring the crowd,
Crowd.
and also like the community marshals, or we can say the personals to manage the crowd flow, and just like your lord,
Did you
there are
did you did you did you had any chance to examine as to what was the aftermath with respect to the Kashi Vishwanath corridor, or what happened at Ujjain when they had demolished many structures to make the Mahakal Shiv Temple corridor? Any clue on that as to very many demolitions were carried out in both these corridors, and what was the impact made on the general public?
Actually, your lord, in the Kashi Vishwanath, they have followed the due process. Like they have consulted with the resident, they have consulted with the devotees and all the stakeholders. But here in this case, they do not have they have not consulted. They don't follow the due procedure of law. Means no consultation with the heritage expert or the stakeholders like the devotees and religious bodies, etc. And they also have some different factual ground backgrounds due to my lord. May I proceed? Your Lordship, in the court, in the case of modern dental college versus state of Madhya Pradesh, the state is required to evaluate the alternatives and adopt the measures which interferes least with the rights, and especially when there is irreversible harm. Your Lordship, here the state fails to establish the form of the necessity. Here the state do not produce any empirical crowd flow studies, pilot projects, or a comparative studies for the cost benefit analysis to show that these non-destructive measures are ineffective. They just directly propose a project. And in India, like the time slot, e-darshan system, tech-enabled flow monitoring, and the CCTV sensor dynamic routings, festival specific temporary protocols, community marshals, and selective retrofittings are available, but they do not follow these measures, my lord. And there's the best example for this is the Tirumala Tirupati Devasthanam, which follow the system of pre-booking and having a safety management for the large crowd. And there's also an example for the Kumbh Mela, which shows that there can be a severe crowding can be managed without the wholesale demolition of the temple. And Your Honor, the present demolition is not the least restrictive, but is completely a most destructive. Your Honor, that the demolition of the century-old temple lanes and heritage structures in Vrindavan involves the irreparable loss, not simply of a physical property, but of a cultural memory, religious ambience, and the intelligible heritage. And the demolition site lies close to the Yamuna River floodplain. Your Lordship, in the case of AP Pollution Central Board versus MP Naidu, the court emphasized that where the irreversible environmental damage is possible, it is the state must adopt the precautionary principles by rushing into demolition and without following the environmental assessment. The respondent have, Your Lordship, in the case of Vanashakti versus Union of India, which held that all the large scale buildings or construction project or the demolition projects has to need a prior environmental clearances when build up near exceed the threshold or which is very adjacent to the sensitive zone. Here it is the Yamuna River. The eviction of hundreds of the resident and more than 500 plus the shopkeepers and priests without the proper fair compensation and the rehabilitation, which is a very core of right to livelihood under Article 21. And in the case of Olga Tallis versus BMC, it was held that, and similarly reiterated in the case of Chameli Singh versus the state of UP, court held that right to shelter does not only include a roof over one's head, but also includes a right to enjoy family, community, and the cultural life. And the demolition of Vrindavan severs precisely these connections. Your Lord, the acquisition and demolition affecting properties who do have the informal and the customary titles, without the proper adjudication and without following the statutory process, which violates the Article 300A, which is a constitutional right, and also the
But that will
mandates
happen only
given
when
under
the
right to fair.
Miss Council, but that will happen once the land gets acquired.
The process has been started, and many of the people
So
cannot
therefore,
get the fair compensation for their land.
that adjudicatory process with respect to compensation will happen only when the land gets acquired. Cannot be prior there to know.
Here, the claim is that they do not get the fair compensation, my lord.
That will
Means
happen
they
once
have
the adjudication
given the
happens.
money, but that money is not.
No. That will happen. Would the monies be
No,
given
no.
prior to acquisition?
Yes,
The
my lord.
acquisition
But
comes
here the
first.
adjudication is, my lord.
Then
Here,
comes the compensation which is offered. And if
yes,
the
my lord.
compensation is not fair enough, only then the landowner goes before the court seeking adjudication of fair compensation.
My lord, they even started
Isn't
the
this
acquisition.
argument? Isn't this argument which is being made by you is too early in the day? Because I believe your whole thrust of the argument is that this corridor itself was not required.
My lord, we contend that there was least restrictive methods were available, but they do not follow those, and they directly come and jump to the this proposal. So we
So
are arguing
therefore,
that.
so therefore, your argument with respect to fair compensation and land acquisition that will be considered later. No, once we approve whether the High Court was right or not right, that the corridor at Vrindavan was required or not required, and or whether the stakeholders have been consulted or not consulted. Speaker tool. Now let me ask you a one very straight question. Could you consider or lay hands on the any of the case laws by the Allahabad High Court or MP High Court when the public went before the said courts when their properties came to be acquired for constructing the respective corridors at Ujjain and Kashi Vishwanath? Of course, all these issues would certainly be would have been considered by the courts there. Did you make any effort to lay hands on any of such case laws
No, my lord.
which are
Actually,
directly impacting your case here?
no, my lord.
Okay, thank you. Anything else you wish to state?
Yes, my lord. Actually, I want to proceed for the issue number 4. That is for the inadequacy and the absence of the consultation with the residents and the shopkeepers and religious body, and especially those who do have the environmental experts. Here, the respondent does
So you
not
mean to
follow.
say that no public notices were given
No, my lord.
inviting objections to the said corridor scheme?
No, my lord. As such
Oh,
process has been not done by the respondent here. And that
right.
is what we are contending here, that the project suffers from the manifest of arbitrariness due to the complete exclusion of the stakeholders without their consultation and violating their fundamental rights. My lord, in the case of Alembic Pharmaceutical versus Rohit Prajapati, the Honorable Court has consistently held that when the administrative action suffers from the fundamental rights of the citizens and requirement of the consultation transform from the discretionary privilege to a constitutional imperative. My lord, the respondent fails to comply with the Land Acquisition and Rehabilitation and Resettlement Act of 2003, which mandatorily requires a public consultation at the multiple stages of the acquisition process. My lord, the section 4, subclause 2nd of this act specifically mandate conducting a social impact assessment study in the consultation with the affected families. And also the section 5 clause 1 of this act specifically requires a public hearing of the affected areas to
Speaker
ascertain
number
the
two,
views
your
of the
time
affected
is
families.
concluded. Speaker number two, your time is
Council
concluded.
extension of 5 minutes more.
No,
Can
you made your
ask.
point. I'm anything else you any other issue which you wish to touch? You made your point here. I understand.
Sure, my lord. Here the respondent fails to conduct the environmental impact assessment, my lord.
That I've
Which is
understood.
a
You made
direct.
a point. You made your point here. That I've understood. Anything else apart from this? Stakeholders not being consulted, environment impact assessment not made, and things like that. Any other thing? No.
Warm greetings to the bench. Council seek permission of the bench to proceed directly with arguments advanced, Your Lordship.
Certainly. Thank you.
Your Lordship, the issue I am dealing with is the first issue is whether the High Court's mandamus under Article 226 directing a particular corridor scheme amounts to impermissible micromanagement of executive policy, and the second issue is whether the reconfiguration of temple alleys and religious circulation routes, implication on Article 25 and 26, which is a right to religion. And the other two issues will be dealt with my second speaker, Your Lordship. So, when we try to understand the question whether the High Court's mandamus under Article 226 amounts to micromanagement of executive policy, first we should understand the principle of separation of power. If we go to the origin of principle of separation of power, Aristotle in his book Politics, he explains what is this principle of separation power. He explains that when he explains the characteristics and the essential elements of the states, he says that one of the essential element is the separation of power. That is, power should not be concentrated in any one of the organ, it should be distributed. Further, another political thinker, Montesquieu, takes further this principle and he develops and he says that to protect the liberty, a power should be distributed between the legislature, executive, and judiciary, and one should not perform the duty of the another, and one should not encroach to the limitations
One
of the
should
another.
not transgress into another's power. No, this is your
Indeed,
wish to
Your
state.
Lordship.
Correct.
Indeed,
Go
Your
ahead. Go ahead.
But when we come to India, if we concentrate on the separation of power principle, we see first we have to examine how it is incorporated to the India. So the first thing and the first foremost for this argument is that this principle of separation of power is not incorporated to India in its strict sense, but certain encroachments are allowed within the constitution. So when we check that, so Indian constitution allowed this constitutionally allowed encroachments by the one branch of the government to the another branch only because of the object of to keep the check and balances of the each other organs. So if you see in this decision also, encroachment of the judiciary to the executive policy, it is permissible only with the intent of keeping a check and balances of executive policy. For example, in the instant case, that is MC Mehta versus Union of India, in this case also, where the Heritage Corridor case, famously known as Heritage Corridor case, the corridor between the Agra and Taj Mahal, Agra Fort and Taj Mahal, there was a proposed corridor project was there. Like the similar circumstances, there also court did not propose any project, but the state proposed the project, but the court approved and enforced that that project should be enforced without any further delay. So to move further, after examining the case, Supreme Court handed over the judgment saying that so as the fundamental rights are at stake, that corridor project should be implemented without any further delay. In present case also, as your lordship mentioned, the court did not propose any particular project, but it just said that it just handed over the judgment saying that already proposed project by the government should be implemented without any delay, as the delay further amounts in a violation of fundamental rights, Your Honor. In the case of Bandi Mukti Morcha versus Union of India, where the labor exploitation projects were already proposed, court held that these projects should be implemented without any further delay. So when is this constitutionally allowed encroachment should happen? When the fundamental rights are at stake, when the fundamental rights are going to be violated, then High Court have all the power to intervene and compel the executive to implement the already proposed project in your case, in your lordship. And the main case and landmark case, that is Narmada Bachao Andolan case, where the dam project was proposed, and in the similar circumstances, many objections were raised that the compensation was not properly given, consultation was not properly taken, and many rights are being violated. But the court held that when there is a question between the individual interest and the larger community interest, we should see the project as a whole. And the court allowed that Narmada Dam project, holding that it is the state's duty that when there is a conflict between the individual interest and the larger community interest, state should choose the larger community interest, Your Lordship. In the
So,
case of
council, in choosing the larger community interest, would the mandatory requirements of the law would be forbidden? You
Your
mean to
Lordship,
say that the stakeholders would not be consulted, required environmental impact would not be done, whatever mandatory requirements are there in law, that would also be set aside. This is
Your
your,
Lordship,
is this your argument?
no, Your Lordship.
Considering the larger public interest?
Your Lordship, when the larger infrastructure projects are proposed, which benefits the millions of people, then
Right.
small inconvenience could be.
Inconvenience is something separate. Please listen to the question properly. would in those circumstances the mandatory requirements of law, may it be environmental laws or other objections which are required to be called for while taking the lands of the people and or such other things, that would be set aside,
No, Your
that
Lordship.
would be brushed aside?
My
Those
argument.
mandatory requirements would not be followed in the larger public interest. Is this your argument?
No, Your Lordship. My argument is not that the individual rights are completely given up to for the community interest. My argument is it is that, Your Lordship, when the larger projects which are which are for the benefits of millions, the fundamental right should be violated in a minimalistic sense, Your Lordship.
How do you
State should
support
take the
this?
all.
How do you support this submission of yours?
Your Lordship, in the case of Narmada Bachao Andolan and the further case Rajiv Surya versus Development of Authority, in these cases also Supreme Court held that it does not mean that when you propose a large scale development and large scale infrastructure, you should give up the individual rights and environmental concerns. But every project have the environmental some or the other impact on the environment. So it is not the complete disregarding these individual rights, Your Lordship, but the state should take care the due process is followed and the minimal interference happened with the individual rights, Your Lordship. That is going to be my further argument, Your Lordship. So if the Lordship may permit me to move to the second issue, Your Lordship, that is right to religion.
Yes, yes,
Lordship,
please.
second issue is that whether the reconfiguration of temple approaches, alleys, and religious circulation routes implication Article 25 and 26, and if so, the correct test to distinguish faithful facilitation from the unconstitutional interference. Your Lordship, our constitution framers have conferred the right to religion upon the citizens equally under the Article 25 and 26. Your Lordship, first to understand the right to religion, we have to examine the verbatim of the Article 25, Your Lordship. The Article 25 itself start with the wordings that is subject to the public order, morality, and health, Your Lordship. That means the wording starts with the Article 25 start with the wordings subject to. That means article right to religion conferred under Article 25 is not supreme, not absolute, but those right to religion, these rights are subject to the public order, public morality, and public safety, Your Lordship. This means that is the intention of the framers to allow the state to interfere in the matters of religion when the religious practice are threat to the public order, morality, and decency, Your Lordship. In so in Durga committee versus Sayyid Hussain Ali, in this case, court reinforced that the principle that not everything carried out in the name of religion is constitutionally protected, Your Lordship. Under this Article 25 and 26, not all the practices, all the beliefs are protected, and all the constitutional protection is not there for all the practices, for all the beliefs under the religion, Lordship. Then the question arises: what are the protected? To what extent? To what practices? To what beliefs? These constitutional protections are implemented. So, to referring to the issue, that is, what is the proper test to distinguish how much the state can interfere? That test is essential religious practice test, Your Lordship. To examine about how much the state can intervene, the essential religious test have been adopted by the Supreme Court, saying that state can only intervene in the matters which is not essentially religious, Your Lordship. In Constitutional Assembly debates, while Ambedkar introducing this Article 25 26, he discussed about while he explaining what is the right to religion 25 and 26. He says
Sorry
that
for
in
the
Hinduism,
interruption. Last two
uh,
minutes left.
indeed, Your Lordship, just 2 minutes, I'll wrap up. Your Lordship, Ambedkar explains Hinduism is a grand umbrella and which includes many practices, many beliefs under it. So Ambedkar explains that not all practices this protection can be expanded, but only to the essential religious. So there should be a distinction between the essential religious practice and non-essential religious practice, and state can intervene in non-essential religious practice, Your Lordship. So it is now my duty to establish that going through that narrow lane
Council,
is not
council,
essential.
could you lay hands on the judgment delivered by the larger bench of the Supreme Court in Ram Janambhumi's case?
Indeed, Your Lordship. In Ram Janmabhoomi, where the issue was about the whether the
Right
that
to religion.
indeed, Your Lordship. But right to religion is not the absolute, but it is under the subject to the public order and morality, Your Lordship. in Ram Janmabhoomi also, when the archaeological when the case was about the dispute about the land, about whom to whom that land
So what
belongs
did the
to.
Supreme Court say in that judgment with respect to this right to religion?
Your lordship, quote, the contention was that places of worship, this places of worship is included under the article 25 and 26, and the deity can be the party in the case, and he has the right to hold the property, your lordship. And after the surveying the land, land was handed over.
Counsel, you're mixing the two. I am not saying right to property. I'm asking what did the judgment say with respect to right to religion?
Your lordship,
Practicing religion.
your lordship,
Let's be honest. Have you been able to see that passage or not?
your lordship,
Could you lay hands on that judgment? Could you see that passage with respect to that in the said judgment or not? Yes or no? Simple.
your lordship, it is the Hinduism is a way of life that is
Forget
referring to
about
the.
Hinduism. Chalo, leave it. Go ahead.
Your lordship, to examine the landmark case about the right religion, there is a landmark case known as Shirur Mat case. Commissioner Hindu Religious Endowments versus Sri Lakshmidhara Tirtha Swamiyar. In this case, court noted that while the essential religious activities are protected, but the activities which are secular, that is economic, financial, or political in nature, that can be regulated by the state, your lordship. So the practice of going through the narrow lanes, which is a threat to the public, that is not a part of essential part of religion, your lordship. That is an economical and secular activity which can be controlled by the state, your lordship. In the case of Shaira Bano versus Union of India, that is famously known as
Time is concluded. Speaker number one from the team two. Next speaker from
Thank
the
you.
team two.
Yes, please.
Warm greetings to the bench. The council seeks permission to argue issue 3 and 4.
Please.
Indeed, Your Lordship. Issue 3 is whether the state's objective of crowd management and public safety under Article 21 justifies the large-scale demolition when less restrictive alternative measures are available. The council seeks permission to argue this in threefold. The first is that Article 21 states that no person shall be deprived of his life or personal liberty except according to procedure established by law. It is the paramount duty of the state to protect the life and liberty of its citizens. But in the present case, it is mentioned in the statement of facts that the corridor will create streamlined access, controlled entry and exit points, medical and security facilities, and cleaner surroundings for both devotees and residents through the proposed project. Due to the only reason is that on August 19, 2022, a massive stampede which took place as a result of because of the narrow lanes of the temple. Further strengthening my arguments, I would like to state a case where Rajasthan State Road Transport Corporation versus Union of India. In plethora of cases, the Supreme Court stated that under Article 21, the right to life also includes right to travel and right to infrastructure. In this particular case, the court held that right to life also includes right to travel. While providing travel facilities, it is the duty of the state to ensure safe and sound darshan is given to each of the devotees. In the present case, the proposed project seeks to ensure the safety travel of the temple, thereby promoting the right to life under Article 21. In Rural Shah versus State of Bihar, in this particular case, the court also held that right to infrastructure is fundamental part of Article 21. Thus, it is the duty of the state to provide adequate infrastructure to promote these rights, which are inherited rights under Article 21, Your Lordships. In my second for argument, I would like to submit that under Section 3 of the Ancient Monuments and Archaeological Sites and Remains Act, it is stated that only monuments which are given protection under the Act are which are of national importance are deemed to be of protected monuments or protected sites. But in our case, the Banke Bihari Temple is neither a protected monument nor a protected site. Thus, the protection under the Act does not extend to the temple. Citing a case, K.K. Verma versus Union of India. In this particular case, it was held that a structure cannot be treated as protected monument under the Act unless it is officially notified in the Gazette. And the same has not been done, Your Lordship. And thus, in another case, Archaeological Survey of India versus K. Murali. In this particular case, the mere antiquity or historical significance of a site does not confer legal protection under the Act. The Banke Bihari Temple is, though of historical significance, cannot claim such statutory protections. And in another case, T.C. Radhakrishna versus State of Kerala. Here, the court held that any action taken in respect of unnotified monuments is legally tenable. Here, the Banki Bihari temple is an unnotified monument, Your Lordship, and no violation arises under the Act. Furthermore, the proposed project is constructive in nature and not destructive. As a state, it is the duty of the state to ensure that not a single stone of the temple has been touched. The core identity of the temple is still being maintained while providing adequate infrastructure around the temple to maintain safe and sound darshan to the devotees. While talking about my third fourth argument that the less restrictive alternative measures are inadequate to maintain the large crowds. The project has been proposed only after considering that the present infrastructure around the temple is dangerously inadequate to manage both daily and festival crowds, thereby posing a grave threat to the public safety. To an article dated August 7th, 2025, in Times of India, the article said that the temple received around 50,000 devotees a day and around 1 lakh and above devotees during the weekends, and annually a 50 lakh devotees used to visit the temple. Such being the case, it is the bounden duty of the state to provide safety measures to the temple. In state of Gujarat versus Union of India, the court held that public safety will take precedence over religious identity. In the present case, the infrastructure project aimed at public safety must take precedence over the conservation of the narrow traditional residential structures that obstruct the effective crowd management, Your Lordships. And in another case, P. Venkateshwaralu versus Executive Officer Tirumala Tirupati Devasthanam, the court held that the right to worship under Article 25 does not extend to demanding darshan at a particular time, but not to allow the devotees in an unregulated manner. Thus, the state taking responsibility of the same is proposing this large-scale project and maintaining the same aesthetics of the temple by making minimalistic changes in the narrow lanes to protect to maintain the Article 21 such that their fundamental rights are not violated. In Travancore Devasthanam Board Employees Front versus State of Kerala. In this particular case, the court recognized that the state's obligation to manage crowds, also emphasizing that the structural solutions such as widening entry and exit routes and creating dedicated corridor projects for the same are being necessary. Thus, the Kashi Vishwanath corridor project was taken as an example for the Banke Bihari temple, ensuring safety. And in another case, Narmada Bachao Andolan versus Union of India. Here, the court laid down the proportionality test. While describing this, I would like to state that the advantages of the dam project outweighed the inconvenience caused to the people. Applying the same test to us, the 5 lakh devotees' lives would be put into jeopardy if we do not take the action immediately. And in Heritage Trust versus Union of India, the court refused to interfere with the construction project near an ancient monument like that of the Banke Bihari temple, which did not violate any legal provisions as I established earlier. Thus, in conclusion, it is humbly submitted that the proposed corridor project is in full compliance with the Ancient Monument Act, and it is the sole objective of the state to uplift the fundamental right of the citizens. If your lordships are satisfied, I would like to move on to the fourth issue.
Please go ahead.
Last 3 minutes
Your
left.
Lordship. Indeed, Your Lordship. Issue 4 is whether the absence or inadequacy of meaningful public consultation of the stakeholders renders the decision-making process arbitrary under Article 14. Article 14 states that the state shall not deny any person equality before law or equal protection of law within the territory of India. Article 14 does not only extends to inequality or discrimination, Your Lordship, but it also extends to any action of the state which is arbitrary or any other aspect. In E.P. Royappa versus State of Tamil Nadu, the Supreme Court expanded the interpretation of Article 14, introducing the doctrine of arbitrariness as a ground for violation of equality. In the present case, no unreasonable classification has been made, nor any injustice has been perpetuated. The state has merely sought to uphold the right to life of the citizens, which has been colored as arbitrary action. In one of the cases, that is State of Himachal Pradesh versus Umed Ram Sharma. In this particular case also, the villagers who moved to the court stating of the state to provide essential infrastructure under Article 21 and 14. Therefore, the development projects, in their very nature, cannot be stalled merely on the ground that every affected individuals has not been personally consulted. Under Section 4 of the Right to Fair Compensation and Transparency Act, Land Acquisition, Rehabilitation and Resettlement Act of 2013, the government can acquire land for public purpose and to conduct a social impact assessment, which is necessary, but which can be disregarded.
Council, can I interrupt you?
Yes,
As
sir.
far as I really appreciate the research work which you have done, as far as these legal submissions which you are supposed to make has been done. Please tell me that with respect to the issue which you are arguing, in the present case, what all has been followed and what all has not been followed.
Indeed, Your Lordship.
In the present case, has
Indeed,
the
Your
state in the present case followed the respective mandates of law or not?
Indeed, Your Lordship. I would like to state the same by quoting a case. In this particular
I do
case,
not want a case law, please. Straight
okay,
away
okay.
come to the fact of this
Indeed, Your
case.
Lordship.
What
The
all,
government,
while conceiving this corridor, what all mandates of law have been followed and what have not been followed? Have the stakeholders been consulted or have they not been consulted? Have you called for a public notice inviting objections on this corridor or not? Environmental impact assessment has
Indeed, Your
been done
Lordship.
or not?
Indeed, Your Lordship. The social impact assessment under Section 9 can be disregarded under urgency matters as per Section
Madam,
40, Your
please
Lordship.
tell me, has it been done or has it not been done?
No, Your Lordship. No, Your Lordship. It has been disregarded as of taking under Section 9 of the Act. And environmental impact assessment has also not been done because uh, development projects and the corridor projects cannot go hand in hand because the construction projects creates certain environmental impacts, but both cannot be disregarded. The environmental concerns are taken into consideration in such a manner that they can be controlled and not disregarded as a whole.
You were taking a cue from the Kashi Vishwanath corridor. In that case, were all these assessments done or not done, or were given a go by?
Your Lordship?
In the Kashi Vishwanath temple, which you were relying upon, in that case also, these social impact assessments and the environmental impact assessments and other requirements of law were forbidden or were they taken?
They were done, Your Lordship, but due to the stampede and there was an urgency, is the main reason
Then
that they have been
why
unsigned.
always the duties of the state they themselves don't do, and it is always on the states freaking conscious of the state that you're required to do that you have to come up with these kind of
Indeed,
things.
Your Lordship. I would like to bring to your attention that there was a large scale restriction from the devotees itself, but for introducing the project itself, Your Lordship, because they are arguing that their fundamental right to religion has been violated, and the same has been established by my co-counsel that it isn't
Thank
violated.
you.
So
Thank you.
time is concluded.
If Your
Speaker
Lordship
number.
is satisfied, I would further move on to the prayer, Your Lordship.
No, prayer, I
Therefore,
understand you wish me to affirm the judgment of the High Court, right? No.
indeed,
That's
Your
the only
Lordship.
prayer. Very fine. Thank you so much.
Now there is
Anybody who wishes to say something in rebuttal?
5 minutes each for the team one and team two for the rebuttal and sub rebuttal.
Yes, Your Lordship. Your Lordship, the petitioner approached the court under the Article 136, which is SLP, Special Leave Petition, Your Lordship. On the other hand, the respondent's memorandum submitted under the Article 32, which is a gross jurisdiction mistake, Your Lordship. On the other hand, Your Lordship, uh, it the petition respondent also stated that Baki Bihari temple is unnotified heritage. So, Your Lordship, it is said that even
You are not primarily concerned with the notification of the monument to be protected monument or not. You are primarily concerned with the economic and other social impacts on the general public, including yourself, with respect to your right to trade and other things that you're basically concerned of.
yes, Your Lordship.
Why didn't you argue anything on that? Apart from,
Yes, Your Lordship, I'm arguing
apart
on
from
that also.
arguing and coming up all with all those legal cases and past precedents, you never mentioned anything which would be affecting the petitioners and the like by having this corridor here.
Your lordship, as you said that there's no point has been given on the environmental impact assessment. Your lordship, that is also in
That's a
my
legal
submission.
requirement. That's a legal
Your
requirement. I am talking about you never, demonstrated anything as to how is it going to impact the petitioner and such like people like the petitioners in that entire area.
your lordship, in my
That's your
part,
basic case.
yes, your lordship, but I started with the issue number one, and you didn't provided me the time for the issue number two, which also include the main concerns according to the right to religion, and which is in under Article 25 and 26.
Your
Your
right to
lordship,
religion is not being affected here.
your
It is
lordship,
it
the
is your right to residence, right to trade, right to do whatever business vocation you people are into. That is what you are basically having the grievance. No,
yes, your lordship,
you never argued on all those issues.
your lordship, in my
That is your
submission,
fundamental. That is your fundamental ground to approach the High Court. No,
yes, your lordship, that it is also said that I particularly mentioned that the right to livelihood, which is under Article 21, which is violated by the respondent, your lordship, but due to the time limited, I didn't get
never mind.
elaborated with
Never
this
mind.
fact, your
Never
lordship.
mind. Anything else?
Uh, no, your lordship, but the last thing is that as the petitioner mentioned, according that it is unnotified monument, so I would like to state that, your lordship, under Article 49, state judiciary in trapezium case held that protection will be given to all those monuments, even if it is not under the any particular act, because Constitution of
But
India
counsel,
is
whether
such
it
that
is protected or not protected, it is not affecting your basic case. Your foundation is not on protection of the monument. Your foundation is on the right to livelihood, right to residence, right to other things in the vicinity of the temple. No,
your
correct.
lordship, because the issue number two, your lordship, as the issue number two particularly involve Article 21 and 26 violation, your lordship, so we have to go according to that issues, your lordship. That's why
Oh,
my submissions are in that
oh,
way.
okay.
Your Lordship, I didn't get specifically what question should I answer from the petitioner, Your Lordship.
I don't think so. You require to answer anything. Whatever you had to state, you have stated.
No, no, Your Lordship. There is nothing
Nothing more
such.
rebuttals, Your Lordship.
Thank you.
Your Lordship, I hereby you requested to provide the valuable feedback to the teams.
Look, both of you, all four of you, you are budding lawyers, students of law. You prepared your matters very well. But one thing I must tell you, in the court of law, you cannot keep reading these whatever you have prepared. You have to conceive, you have to understand, and you have to focus as to what are the issues for the consideration of your case. You have to realize that what is the basic foundation of your case on which you are building up your case. You have to first come up with those issues. Legalities and other things come later in point. But first of all, you have to open up saying that this is what the petitioner is, this is how the petitioners and like others are going to be affected in the event this is constructed in the manner if it is allowed to be constructed. As far as legal aspects are concerned, that certainly can support. But first, you have to understand and make your points to the court as if, there's nothing before you. You only make readings when it comes to judgments or some passages for the court to consider. But anyhow, both of you, both the teams, you have done a great job, well prepared, and please focus on the core issues of this case and see to it that what requires for the court to be considered and what not, rather than keep piling up your arguments with precedents, whether it is taken, whether it is required or not required.
Thank you, both the teams. I request the participant to kindly leave the meeting room and we would request the judge to please stay in the courtroom. Uh, Sir, in 5 to 10 minutes, you can analyze the performance of the candidates and you can share with us.
Okay, thank you.
Oh, thank